About 1,500 years ago in England, proverbially in the forests of Wessex, as one of my old law professors used to say, people got together and they decided that trial by combat didn't always produce a fair result. So over time, more than 1,000 years, trial by advocacy was developed, and the common law that is the foundation of U.S. law was developed in England. It's a substitute for trial by combat. Now it's trial by mouth and trial by fact, judged by a jury of your peers. That's an extraordinary accomplishment for any civilization, to find a way to resolve horrific disputes that would ordinarily be resolved only through violence in a peaceful way. And over time, we have come to accept that that's the way to resolve disputes. One of the things that's happened in the 30 years or so that I've been practicing law is that people have come to realize that contracts and disputes are only as good as the muscle that the parties will put into defending them. And by muscle, in this case, I mean money and time and effort. A contract between parties where one person is never going to fight back essentially is no contract, because that lets the other person take advantage, knowing that there's never going to be any consequences. My job is to provide the consequences. Sadly or otherwise, no one contacts the Kaufman Law Group because they're happy. My firm never has had an opportunity to do win-win work of buying and selling firms or adoptions. My firm does one thing. We fight for people who have been trespassed against. And as I said, we provide the consequences when people violate someone else's rights.